So picture this. Your small town is up against a plan to build a massive new cell tower, maybe right next to a park or a school. You protest, you organize, but everywhere you turn, you're told it's a lost cause, that some powerful, faraway government agency gets the final say. For decades, that was just how it was. But what if I told you the entire rulebook for that fight just got thrown out the window? For more than 30 years, a sentence like this was basically a legal stop sign. It didn't matter if it was Connecticut's Siting Council or a federal agency like the FCC, the message was always the same. We decide, you deal with it. And that, as you can imagine, left communities all over the country feeling completely powerless. Now, that feeling wasn't just in people's heads. It was the direct result of a legal idea that was so dominant, you could almost call it the villain of our story. This was an entire era built on one single concept. So what exactly is agency supremacy? Well, think of it like this. It was basically a belief system where government agencies got a free pass. The assumption was that they knew better than anyone, even judges, how to interpret the laws Congress wrote. So the courts were just expected to nod along. The agencies, well, they held all the cards. And the real-world impact of this was just huge. When a community tried to challenge a project over, say, environmental worries or because it violated local zoning, they were essentially told their concerns didn't matter. The agency's reading of the law was treated as gospel, and fighting back was seen as a total waste of time. But then everything started to change. Beginning in 2022, a series of absolutely landmark Supreme Court decisions started to take a wrecking ball to this entire framework. It was a massive turning point in a story that had been going on for decades. And I'm not exaggerating here. In just a few short years, the legal foundation that had propped up agency supremacy for a generation was completely pulled out from under it. The era of just automatically trusting the agencies, yeah, that's officially over. These 4 cases, Loper, Bright, Sheetz, Dobbs at McLaughlin, are really the heroes here. Together, they've created a brand new legal toolkit that has handed a tremendous amount of power back to states, to towns, and to individual property owners. All right, so let's get into the nitty-gritty. Let's break down exactly how each one of these 4 cases gives communities a new and very specific power to fight back and protect their rights. First up, we have the big one. This case went right for the jugular of agency supremacy. It took on a 40-year-old legal idea called Chevron deference, which honestly was the main pillar holding the whole system up. And the takeaway here is absolutely crucial. The Supreme Court basically said, nope, not anymore. Courts can no longer just take an agency's word for what a law means. Judges have to actually read the law for themselves and decide what Congress meant. That legal shield that agencies hid behind for 40 years, it's just gone. Okay, next up is a case called Sheetz v. Eldorado, and this one completely rewired the rules of land use law. It protects property owners from getting hit with crazy fees for public projects, even if those fees come directly from a state law. This is a massive deal. It means if a state passes a law that forces your town to accept, say, that new cell tower and it tanks the property values around it, you can now challenge that as an unconstitutional taking of property. And if you win, the government might have to pay for that loss in value. Now, the third case, Dobbs v. Jackson, is obviously famous for its ruling on abortion. But a key part of that decision also delivered a powerful reminder about a fundamental constitutional principle that has huge implications for local control. The ruling basically put a giant exclamation point on the idea that any powers not specifically given to the federal government belong to the states and the people. And since things like zoning and land use have always been local issues, this case gives new constitutional muscle to a town's authority over its own territory. And finally, we've got a case that might sound a little technical, but trust me, this one smashed a huge roadblock that agencies absolutely loved to use to stop lawsuits before they even got started. You see, for years, agencies used a law called the Hobbs Act to argue that you had only 60 days to challenge one of their rules. If you missed that tiny window, you were out of luck forever. Well, the Supreme Court just threw that entire argument out, saying that local courts can review an agency's bad interpretation of a law at any time. The clock no longer runs out on your rights. So what happens when you put all of these decisions together? Well, you get a really stunning before and after picture of the legal world we're all living in. I mean, just look at the difference here. This is a fundamental power shift. The old rule was all about the agencies. They claimed all the jurisdiction, and the courts just went along with it. Now, the courts and the Constitution are back in the driver's seat. It's a complete 180. And what's really wild is how fast this all happened. We're talking about more than 30 years of one system, and then bam, the entire legal landscape gets remade in just a few Supreme Court terms. It's kind of breathtaking, really. Okay, so we've covered a lot of legal ground, but let's bring it back down to earth. What does all of this actually mean for you, for your town, for your community? How does this translate into real-world power? This is the million-dollar question, right? Now that all these old barriers have been torn down and these new legal tools are available, what can a town or a group of residents actually do that they couldn't before? Well, here's the new playbook. Thanks to Loper Bright, you can now go to court and challenge an agency's bad reading of a law. With the power of Sheetz, you can argue that a new state mandate is an unconstitutional taking of your property. Using the principles from Dobbs, you can assert your constitutionally protected right to local zoning. And now that McLaughlin has kicked the door open, you can finally force an agency to listen to your evidence on safety and the environment. You know, this quote really nails it. This isn't just some minor legal tweak. This is a generational shift in power. It puts communities and everyday people back in the game, giving them the power to actually defend their land, their rights, and their own future. So, the old era is over. The age of agency supremacy is done. The legal tools are now in the hands of the people and their local governments, and the balance of power has definitely shifted. The only question now is, what happens next?